Hello friends, I welcome you all at Swayam platform. Today we are going to discuss a specific topic, divorce by mutual consent. But before starting the today's lecture, I want to summarize what we discussed in the last class. In the last class, we discussed the special grounds available to the wife. Friends, Section 13 subclass 2 identified 4 special grounds which available only to the wife. Friends, these 4 grounds are special, and why it is available? Because it is relevant in the context of women, friends. Friends, for example, if husband is guilty of rape, sodomy and bestiality, if after the maintenance order there is no cohabitation, then wife have a special right to file a divorce. The right of repudiation means when the marriage of wife was before the age of 15 year and she repudiated the marriage after 15 year but before 18 year, she may repudiate and file a petition for the divorce, friends. Simultaneously, in reference to the bigamy by the husband, in a case of pre-act marriage, wife is entitled to file divorce petition. So therefore friends, in the last class we discussed the 4 specific points are grounds available to the wife exclusively for filing a petition. Pre-act marriage, husband is guilty of rape, sodomy and bestiality, maintenance order and there is no cohabitation, and she repudiated the marriage after 15 year but before the 18 year. Friends, we also discussed that the provision of section 30 subclass 2 is constitutional because constitution permits parliament to enact such laws for the betterment of the women. Friends, now I want to concentrate on today's lecture. The topic is divorce by mutual consent. Friends, as you are aware about that, we discuss about the different theory related with the divorce. One theory is a fault theory, another theory is a irritable breakdown or frustration of marriage theory, and simultaneously friends, consent theory. Friends, consent theory is totally different than the other two theories, because consent theory try to accommodate the idea that there is no reason to prove any kind of fault for the purpose of divorce. You may prove we both are agree not continue marriage, then you may avail this ground. So therefore friends, before starting the discussion, I want to explain you objective of the today's lecture. Friends, the learning objective includes the basis of divorce by mutual consent, the procedural requirement for grant of divorce under section 30 capital B, meaning of the term living separately and not able to live together, judicial interpretation of section 13 capital B, nature of cooling period, whether cooling period is mandatory or directory, and we also discussed the law of consent under the divorce by mutual consent. So these are the learning objectives of the today's class. Learner will able to comprehend each and every dimension of the divorce by mutual consent after the completion of this class, friends. So now I want to focus on the very provision. The provision is given under Hindu Marriage Act section 13 capital B, friends. The primary observation is divorce by mutual consent was unknown to the Hindu law. It was permitted in different part of India by various provincial legislations. For example, Travancore-Izaha Act 1100, that is 1925 AC, the Cochin Mariukam Act, and the Coaching Nayar Act 1113. So these provinces already accepted the idea of divorce of mutual consent and they developed the law in their territory before the independence. But after the independence, when we started codifying our family laws, we not accepted the idea of divorce by mutual consent. Why it is not accepted? Because people strongly felt that Hindu marriage is a ceremony which exists during the life and beyond that. Therefore, it cannot without any ground easily break by either party of marriage. Therefore, it was not included in our act, friends. It was introduced first time at the national level by the Marriage Law Amendment Act 1976 as a section 30 capital B of Hindu Marriage Act 1955. Section 30 capital B of Hindu Marriage Act is retrospective and prospective both. How we can deduce it? Means a marriage which was solemnized before the 1976 or after the 1976, in both the cases, the parties of marriage are entitled to avail the divorce remedy under this section. Therefore, it is retrospective as well as prospective. Friends, the marriage may solemnize before or after the Amendment Act. In both the circumstances, party may proceed divorce on the ground of divorce by mutual consent. Friends, now I want to focus on certain other aspects of the divorce by mutual consent. Friends, for the degree of divorce, both the party of marriage must agree to dissolve their marriage. This is the first fundamental point, friends. Both the parties must agree to dissolve their marriage. If they are not agree, then court cannot pass the order. This is very essential legal requirement for availing the benefit of section 30 capital B or arguing your case before the court on the basis of 13 capital B, divorce by mutual consent under Hindu law. Friends, the provision suggests that parties follow more civilized and cultured way of dispute, friends. Friends, when you are going divorce on the basis of fault theory in adversarial system of justice, then you are arguing that due to your fault something happened. But this is totally different. This is the more civilized way handling a dispute. We both are agree, we are not blaming each other, kindly resolve and dissolve our marriage. So therefore, it is treated as a more civilized methods of dispute, friends. Friends, the fundamental point is mutual compromise between the party does not itself dissolve the marriage. Mutual compromise between the party is one thing, and on the basis of mutual agreement, court passed a decree is another thing. Friends, thumb rule of the Hindu Marriage Act is the marriage cannot be dissolved without the formal decree of the court. Therefore, we should be very clear that divorce by mutual consent not mean that by agreement both the parties are living separately. So long as there is a no judicial pronouncement, status of husband and wife remain exist and they cannot considered as divorced. This is the point. Friends, to obtain the decree of divorce on mutual consent, the procedure laid down under the section 13 capital B must be duly followed. Divorce by mutual consent falls under the non-fault theory, where the party do not have to prove fault on the part of another parties of the marriage. Friends, now I want to focus on the legal provisions related with the divorce by mutual consent, which is provided under section 30 capital B, aided by the Marriage Law Amendment Act 1976. Friends, as per the 13 capital B clause 1, subject to the provision of this act, a petition for the dissolution of marriage by a decree of divorce may be presented to the district court by both the parties of marriage together, whether such marriage was solemnized before or after the commencement of the Marriage Law Amendment Act 1976, on the ground that they have been living separately for a period of 1 year or more, that they have not been able to live together, and that they have mutually agreed that marriage should be dissolved. And the second, on the motion of both the parties made not earlier than 6 months after the date of the presentation of petition referred in subsection 1 and not later than 18 months after the said date, if the petition is not withdrawn in meantime, the court shall, on being satisfied after hearing the parties and after making such inquiry as it think fit, that marriage has been solemnized and that the averment of the petition are true, pass a decree of divorce declaring the marriage to be dissolved with effect from the date of decree. Friends, a provision of the divorce by mutual consent as prescribed by the law, section 13 capital B. On the basis of the reading of provision, we are able to draw certain fundamental fact. On that basis, we can avail the remedy of the divorce by mutual consent. Parties of marriage may avail the decree of divorce. Means section 13 capital B dependent on 3 important facts. The first is, the parties have been living separately for a period of 1 year or more before filing the petition. Second, the party have not been able to live together. And the third is, the parties have mutually agreed that their marriage should be dissolved. These are the 3 facts to be proved for the purpose of the remedy under section 13 capital B. This is very fundamental requirement. They are not actually living. They are not able to live together. They are mutually agreed to dissolve the marriage. They are not living. They are not able to live. They mutually agreed for the purpose of dissolving the marriage. Friends, now I want to explore the first fact which is required for the purpose of divorce by mutual consent. The party have been living separately for a period of 1 year or more before filing the petition. The fundamental requirement is, 1 year or more immediately before the petition. Living separately means not living as husband and wife. And the third, the expression has no reference to the place or places of their living. They may live under the same roof but do not perform their marital obligation, or they may perform these obligations even when they are living different houses or place. Therefore, mental attitude or the state of mind towards each other is very important. Friends, what is the idea? They are not living together. They are living separately. And they are living separately more than 1 year. This is the fundamental requirement for the purpose of filing the petition under section 30 capital B. Friends, be careful. they are not living together as a husband and wife. It may happen when they reside within a roof, or they may living at separate places, friends. Therefore, factum and mental elements, both the elements are useful in order to understand the idea. But the first point is very simple and clear. For the purpose of initiating a petition under section 30 capital B, the law is very clear and simple, that is, they are not living together and more than 1 year time has been lapsed. This is the fundamental requirement for the purpose of thinking about the mutual divorce. Now friends, the second fact, party have not able to live together. They are not living, and the second requirement is they are not able to live together. Friends, be careful. Not living means they are willfully they are not living with each other. Not able due to any circumstances or any problem, they are not able to live together. Friends, the fundamental purpose is whether both the parties of marriage is living together or not. If they are living together, the divorce by mutual consent is not possible. The fact should be proved before the court is they are living at separate place, or actually they are living in a place but have no relation between them. Now friends, focusing on second element, they are not able to live together. Means friends, it may be due to any external reason or due to any other internal or subjective reasons. For example, they may not like each other, both like some other person, philosophy of life, social view or habits or way of life etc. is different, physical incapability to enjoy the married life, due to their employment they are not able to live together. Means the substance of this condition is that their marriage is broken down, in fact they are not living together. Friends, the third fact which is required for the purpose of divorce by mutual consent is the party have mutually agreed that their marriage should be abolished. Friends, the phrase the party have mutually agreed that their marriage should be dissolved to be read with section 23 1BB. Section 23 of Hindu Marriage Act 1BB provides that when a divorce is sought on the ground of mutual consent, such consent has not been obtained by force or fraud or undue influence. This is the requirement of section 23 1BB. Friends, therefore, as per section 23 1B, their mutual concern and consent of this effect must not be obtained by force, fraud and under influence. No other ground or reason is required. Friends, remedy is possible only on three grounds. They are not living together, they are not able to live together, they are mutually agreed to dissolve the marriage. Three facts is sufficient. There is no need to prove other facts or grounds for the purpose of obtaining the relief under section 13 capital B, friends. As it is pointed out by the case Ravi Shankar versus Shraddha Vishwakarma, where it was held that it is not necessary for the party to plead any other ground laid down for the divorce under the act. If it were necessary to present some other ground also, the very making of the provision of divorce by mutual consent would become meaningless. Obviously, friends, if other grounds are required, then why mutual consent is required? The mutual consent per se is sufficient. There is no need to prove other grounds for the purpose of dissolution of marriage. Similarly, friends, another case is Indrawal versus Radhe Raman and another, AIR 1981, Allahabad High Court, page number 151. The parties are not required to prove any ground for dissolution of marriage, but court have to simply find out that their mutual consent is not the result of any conspiracy between the parties and between them. So these are the two cases which concluded that there is no need to prove any further ground when you are pleading divorce on the basis of mutual consent. Now friends, we may classify entire section 30 capital B into broad category. One category is about the substantial provision and another is procedural provisions. Substantial provision means they are not living together, they are not able to live together, they mutually agreed. But procedural requirements should also be fulfilled for the purpose of remedy, that is given in section 13 capital B, friends. The first is there must be a joint petition by both the parties. Petition must be presented by both the parties. Friends, only one party cannot present a petition under this section. In a case of Ranjana Munshi versus Taral Munshi and another, it was held that in matrimonial petition under section 30 capital B, the father of either parties has no locus standi unless one of them is minor or lunatic. Friends, it is necessary to comply with other provision of this act. Petition must be joint petition and you must be comply other provision of this act, friends. For example, friends, section 19, the court to which petition shall be presented. Section 20, the content and verification of petition. And section 23, decree in proceedings. These are the criteria, friends. Now friends, I want to discuss a controversial issues under section 13 capital V, that is the cooling period. And the law relating to cooling period, what is the purpose behind the cooling period and why the cooling period is mandatory, or in which circumstances cooling period may be overlooked by the court, friends. Friends, under section 13 capital B, the first motion is made at the time of filing of the case and second motion need to be filed after 6 months but before 18 months of the original petition, friends. At the end of 6 months, the court will not proceed with the petition suo motu. The party have to move the court by way of second motion and only thereafter the court will proceed. The second motion must be made by both the parties. It is mandatory requirement. If it is not made by one of the parties or by only one of the parties, then no decree will be issued. Only on the mutuality of consent, the divorce will be granted. That mutuality should be retained till divorce is granted by the competent court. Friends, divorce by mutual consent and cooling period, friends. We think about the two different kind of stage. One stage is first motion, another stage is second motion. First motion means when you approach the court first time, there is a need of joint petition and your petition is now in cold storage for next 6 months. After the expiry of the 6 months, the statutory obligations on the parties, they should move again and request to the court to dissolve their marriage. So this is the first motion and second motion. The time duration of the first motion means at the time of petition. Second motion means a motion which is initiated by the parties of divorce after the 6 month of the first motion but before the 18 month of the first motion. This is the point which should be considered when we discuss about the cooling period, friends. Friends, now the second idea is, the new question arises that whether a court can entertain the second motion made after the expiry of 18 months from the date of first motion or not. Second motion presented by the parties of divorce after the expiry of 18 months. The law is very clear. The language of section 30 capital B is not after the expiry of 18 months. Second motion must be presented. But what will happen if second motion is presented by either party of marriage after the 18 month? In a case of Santosh Kumari versus Birendra Kumar, the court observed that section 30 capital B subclass 2 only contemplates the time limits for the withdrawal of first motion and not outer limit for filing the second motion. Hence, the second motion made thereafter can be entertained by the court, friends. Friends, this is the point. The 18-month time which is given in section 30 capital B subclass 2 interpreted by the court outer limit to withdraw the first motion. This is not an outer limit to file second motion. How the court interpreted the language of section 30 capital B subclass 2 is very interesting, friends. Not before the 18 month means first motion may be withdrawn within 18 months from the date of original petition, but second motion may be made after the expiry of 18 months, friends. Friends, does it mean that party may come to the court after the quite long duration from the first motion? The answer is affirmative. Yes, party may return to the court after howsoever long time they like. There is no legality in this. They may come whenever they feel that marriage is insufferable for them, and they may keep away from the court as long as they can bear the marriage. Friends, but the point should be very clear, friends. But second motion may be made before the court after the 18 month. It not mean that after 4 year, 5 year, 6 year. But everything should be defined and explained in the light of reasonability. If there is a reasonable criteria, then it is accepted. So this is the procedural requirement, friends. There must be a cooling period, and cooling period is mandatory, friends. Friends, now the fundamental question is, what do you mean by cooling period? Cooling period means a period provided to both the parties. They should think and rethink over their step, what they actually want. Suppose, friends, once they agreed, they filed petition. Now they are thinking that they committed wrong because something should not be happened. The cooling period means a kind of safety valve, a time period which is provided to them. Please rethink what you are going to do. So therefore, cooling period is important, friends. Friends, a fundamental question emerges in the discourse of law is whether cooling period is mandatory or directory. Mandatory means the court will not entertain second motion before the 6th month, and it directory means the court may entertain the second motion before the expiry of 6th month. It is mandatory or directory. Friends, different high court have a different opinion, like Punjab, Haryana High Court, Andhra Pradesh High Court treated that cooling period is mandatory. On the other hand, the Delhi, Karnataka and Madras High Court concluded that it is directory only. But friends, now we resolve the dispute with the development of the case laws, friends. Now I want to focus on the judicial development. Mamta versus Ravindra, Punjab and Haryana High Court, 1961, the court observed that this is mandatory provisions for the purpose of giving time to the parties to rethink over the drastic step. The court will not take up the petition when the husband and wife come again to the court after the expiry of the 6 month for the relief of divorce. The point is very clear, friends. The court will not take up a petition when the husband and wife come again to the court before the expiry of 6 months for the relief of divorce, friends. They need not to come personally, they may be present through their counsel, friends. Devender Singh Narula versus Meenakshi, 2012 Supreme Court. The court observed that section 30 capital B itself provides that for a cooling period of 6 months on the first motion, it has the purpose that the party may change their mind, therefore cooling period is mandatory. Friends, in another case, Anjana Kishore versus Puneet Kishore, the court held that the period of 6 months can be waived off by the Supreme Court in exercise of power under Article 142 of the Constitution. So what the story may be concluded, friends? It is mandatory. Why mandatory? Because of purpose. And purpose is very clear. They should rethink about their drastic step. The court cannot bypass the procedural requirement, but Supreme Court finally concluded that the court may waive cooling period by exercising its power under Article 142 of the Constitution. Friends, in the case of Manish Goyal versus Rohini Goyal, 2010 Supreme Court, the court held that Article 142 could not be invoked contrary to a statutory prescription. They referred the larger bench to resolve the conflict, but the case ended in the meantime as the parties got decree of divorce. In this context, friends, a very famous case came before the Supreme Court in the year 2017, Amardeep Singh versus Harveen Kaur. The fact of this case is the party got married on 16th January 1994. They had 2 children, one in 1995, another in 2003. Dispute was between them that they were not able to reconcile their differences and had been living separately since 2008. Civil and criminal proceedings were going on against each other. However, they managed to finally settle their differences on 28th April 2017. Under section 13 capital B, it was agreed that 2.75 crores will be paid by the husband to the wife as a permanent alimony, and custody of child would remain with the husband. Friends, on 8 May 2017, the Tisajari Court recorded their statement that 2 checks of 50 lakhs each were honored. Issue in this case: whether 6 month cooling period under section 13 capital B is mandatory or it could be waived off under certain circumstances by the court. Appellant argued that the waiting period is directory and can be waived off by the court in exceptional circumstances. Supreme Court, in a case of Nikhil Kumar versus Rupali Kumar, 2016, has waived off the period by using the extraordinary jurisdiction under the Article 142. Section 30 capital B1 discuss the jurisdiction of the court, and the petition become maintainable only when the parties are living separately for more than 1 year. Thus, section 13 capital B is merely a procedural in nature. How we can understand the argument of the appellant, friends? It may be waived because Supreme Court already waived. You cannot file a petition without living separately more than 1 year. The parties living separately, how you are imposing, why you are imposing a condition on the parties if they really actually living separately before the presentation of petition? Friends, judgment is very interesting, friends. The court finally declared that the court may waive the cooling period when the court is satisfied that the period of 6 months provided under section 13 capital B subclass 2 along with the period of 1 year for moving the petition for the divorce under section 13 capital B subclass 1 was already over before the petition. Means they are living separately more than 1 year. Option of mediation and conciliation have been used and failed to settle the differences in terms of the provision of CPC and Family Court 1985. The dispute regarding the alimony and the custody of child have been settled by the parties. The waiting period would cause hindrance in the resettlement of the parties. It was also directed that application for waiving of period of 6 months could be made by the party after a week from a day of the petition for seeking the mutual divorce is presented to the court, and the same is allowed by the court after considering all the factors and satisfying itself. So friends, finally the court in 2017 concluded that waiting period may be waived if they are living separately, mediation and conciliations options are exhausted, alimony and child custody issues resolved, then why you are waiting for that? You may resolve the marriage and waiting period may be waived off. Friends, now I want to focus on section 30 capital B subclass 2 where the terminology is used. Court shall is mandatory provision, friends. Parties may make a motion after 6 months and before 18 months from the presentation of the petition. The court will start hearing the parties, making inquiry in order to satisfy first whether marriage was solemnized or not, that the statement in the petition are true or not, consent is obtained by force, fraud or undue influence or not, one party was absent and not questioned by the other party. Order 19 Rule 1 of the CPC provides that any court may at any time for sufficient reason order that any particular fact or facts may be proved by affidavit only and no need for cross-examination. If all the above facts are proved, the court is obligated to pass the decree of divorce. Marriage dissolved from the date of decree. Then court shall. If the court satisfy, then court cannot think that it should be in pending state. No, it should be dissolved, friends. Friends, in the case of Hitesh Bhatnagar versus Deepa Bhatnagar, the language of section 30 capital B subclass 2 of the act is clear. The court is bound to pass a decree of divorce declaring the marriage of the parties dissolved if the condition of section 30 capital B are fulfilled. In a case of Srimati Swati Verma versus Ranjan Verma, the Supreme Court held that the parties of marriage had filed different cases under section 498A, section 406 IPC and section 3 and 4 of Dowry Prohibition Act. The Supreme Court itself dissolved the marriage by mutual consent under its extraordinary jurisdiction under Article 142 of the Constitution, dissolved the marriage by the decree of divorce by mutual consent under section 30 capital B of the Hindu Marriage Act. Friends, now the point is non-compliance with the compromise term. Suppose they agreed and we will resolve our dispute on certain term. If it is not happened, then what will happen, friends? In a case of Payal Jindal versus A.K. Jindal, 1992, the Supreme Court made an order for the payment of maintenance to the wife in a decree for divorce by mutual consent. Any default in the payment, the order of decree shall stand revoked automatically and divorce proceeding will be revived in the family court again. Suppose if the decree of divorce is based on certain condition, if you are not complying, then it will be presumed by the court is decree of divorce, petition for divorce is still continue. decree obtained by fraud. In a case versus Puspalata Raut versus Damodar Raut, the decree obtained by fraud and therefore decree can be recalled under Order 47 Rule 1 of CPC. Order 47 Rule 1 of CPC provides that application for the review of a decree or order, it outlines the circumstances under which a party can seek to have a court reconsider its previous decision. Friends, right to petition again. The answer is affirmative. The party may withdraw the petition within the prescribed period of 18 months. Withdraw the petition does not show they should be disqualified seeking the relief again. In a case of Pralabha Subbalakshmi versus Pralabha Anant Venkata, the High Court of Andhra Pradesh held that refusal of divorce under Section 30 capital V does not preclude either of the party from filing a petition for the divorce under Section 30 or even a fresh joint petition under Section 30 capital B. Now I want to focus on a recent case, Shilpa Shailesh versus Barun Srinivasan, 2023 Supreme Court. The Supreme Court examined the scope and extent of its power under Article 142, Clause 1 of the Constitution in the context of divorce proceeding. In this case, the couple had been living separately for more than 6 years with a numerous attempts at reconciliation proving futile. They filed many cases against each other. The issue and the decision of the court. Whether Article 142 subclause 1 allow deviation from the established procedural and substantive law. The court held that Article 142 subclause 1 permits deviation from its established law when necessary. Whether upon settlement the court can dissolve a marriage by mutual consent by passing the procedural requirement of Section 13 capital B. The court affirmed its discretion to allow the dissolution of marriage in such cases, friends. Withdrawal of consent is another issue for the purpose of divorce by mutual consent. Whether a party can withdraw his or her consent after presenting the petition. The Supreme Court in Surestha Devi versus Om Prakash in the year 1991 held that the purpose of putting the petition in the cold storage is that parties may reflect on their own move and change their mind. This change need not be in the mind of both the parties, it may be only in that of one party. If one party withdraw the consent, it is good enough to not consider, not proceed further in this case, friends. In Ashok Hurra versus Rupa Bipin Javeri in the year 1997, Supreme Court observed that it appears to us the observation of this court to the effect of that mutual consent should continue till the divorce decree is passed, even if the petition not withdrawn by one of the parties within the period of 18 months appears to be too wide and does not logically accord with Section 30 capital B of the Act. Friends, there is a contradictory opinion about the withdrawal of consent. In one hand, Supreme Court argued that withdrawal of consent is allowed because of the purpose of this law. On the other hand, the court concluded that no, you must examine the facts and circumstances. Friends, now the point is very clear and simple. The withdrawal of consent has to be communicated to the court by the party personally or through the counsel. Where it is not done, then the court rightly presumed that consent for divorce was continued. The withdrawal of consent of divorce by mutual consent must be a positive act of the withdrawing party. If he does not come to the court with the other party at the time of the second motion, the court would not draw the inference in the favor of the consent. The consent must be specific, must be acted properly, friends. After this discussion, friends, you may think about certain point. What is cooling period? What is the purpose of cooling period? Does the inclusion of section 30 capital B bring down the nature of marriage from divine conjugal to the human contract? Friends, before closing my today's lecture, I want to summarize entire discourse. Section 30 capital B originally not provided under Hindu Marriage Act. It was introduced in the year 1976 by Marriage Law Amendment Act. Friends, you are bound to prove 3 facts for the purpose of remedy. The first is they are not living together, they are not able to live together, and they are mutually agreed to dissolve the marriage. After proving this fact, parties of marriage may proceed further. Certain procedural requirement is also there. Petition must be joint petition, and there must be first motion, there must be second motion. At any cases, after the first motion, you should wait for 6 months. 6 month time after the first motion is a cooling period. The fundamental question is, friends, whether cooling period is mandatory or directory. The Supreme Court concluded 2 points. Under Article 142 of the Constitution, Supreme Court may bypass cooling period and award the decree of divorce. Simultaneously, Supreme Court also concluded that any court, district court, may bypass the cooling period if the court satisfied that they are agreed, they are living separately more than 1 year, and reconciliation and mediation exhausted. There is no possibility of the reconciliation, maintenance and alimony and custody of child issue is resolved. Then cooling period may be waived by the party, friends. So now, friends, cooling period become directory. It may be waived by any court on the basis of the Supreme Court judgment, or Supreme Court itself may waive the time under Article 142 subclass 1 of the Constitution. Friends, the consent is also important, and therefore consent should be continued before the passing the decree, friends. Suppose if on the basis of certain condition divorce decree is passed and no one is complying the condition, then court will treat it the divorce petition is still alive. These are the points related with the divorce by mutual consent. Thank you for your cooperation, friends. Thanks.